for everyone for the holiday season, for peace, love, happiness, and also, too, for the recent tornado victims' families that just happened recently. May we have a moment of silence for them, and we'll go right into the Pledge of Allegiance. Before we start with this evening's agenda, I'd like to welcome our residents of Riviera Beach, our visitors, our viewing audience, and extend everybody a happy holiday season. Next, we're going to go on to item number 2. Madam Clerk, may we have an attendance roll call, please?
Anthony Brown.
Present.
William Wiley.
Present.
Frank Fernandez.
Present.
James Gallen.
Present.
Margaret Shepard.
Present.
Renee Burgess.
Yes, here.
Evelyn Harris Clark.
Present.
Moe Tinubi. Russell Barnes. You have a quorum.
Thank you. Do we have acknowledgement of board member absence notifications on record?
Yes, Madam Chair. Both alternates advised that they would be absent this evening.
Thank you. At this moment, on item number 4, for the board here to have looked at our agenda, do we have any additions to the agenda right now? Any additions to the agenda, as well as staff? Any
No, ma'am.
additions?
I do not.
Okay, thank you. Any deletions to the agenda? Staff?
None.
Okay, thank you. Item number 5, do we have any disclosures by board members?
None received, Madam Chair.
Okay, we're good. Okay. May I have an emotion to adopt the agenda as presented?
So moved.
Second.
Thank you. May we have a vote, Madam Clerk?
Anthony Brown.
Yes.
James Gallen.
Yes.
Renee Burgess.
Yes.
William Wiley.
Yes.
Margaret Shepard.
Yes.
Frank Fernandez.
Yes.
Evelyn Harris Clark.
Yes,
Unanimous vote.
thank you. All right. Do we have any unfinished business, Ms. Savage?
No, ma'am, we don't.
Okay. Let me go back to the item number 6. I missed right over it. We have had an opportunity to get the minutes in advance. So at this point, I'm going to ask for a motion for the approval of the minutes.
So moved.
Second.
Again, may we have a roll call?
Anthony Brown.
Yes.
James Gallen.
Yes.
Renee Burgess.
Yes.
William Wiley.
Yes.
Margaret Shepard.
Yes.
Frank Fernandez.
Yes.
Evelyn Harris Clark.
Yes,
Unanimous vote.
thank you. Okay, we're going to go on to item number 8 on our agenda, and we're going to start with new business.
Thank you, Madam Chair. For the record, Mary Savage Dunham. Our first item of new business is an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending Chapter 23, Coastal Construction, Article 3, Wetlands Preservation, updating Appendix 1, Wetland Preservation Areas of Riviera Beach, and Appendix 2, Wetland Vegetation, providing for applicability, repeal of laws in conflict, severability, and codification, and providing for an effective date. And Madam Chair, this item will be presented by the Director of Development Services, Mr. Clarence Sermons.
Okay, thank you. Hi, Mr. Sermons, can you give me just a moment to get to that section on the computer?
Absolutely.
Thank you. I'm scrolling down to get to the visuals.
Okay, there it is, right down. There you go, that's this right here, and takes it down. This is what he just read.
Okay, thank you.
Thank you, sir.
All right. Good evening, Madam Chair. Again, for the record, I am Clarence Sermons, Director of Development Services for the City of Riviera Beach. I am before you to present this item, which was just read into the record related to the Wetlands Preservation Ordinance for the City of Riviera Beach. So to provide a overview of what's contained in this item before you. This existing ordinance provides that the lands adjacent to the Atlantic Ocean and Lake Worth should be conserved by prohibiting any activity that would destroy or significantly disrupt the biological capacity of those areas. The ordinance provides the general location of the wetlands preservation areas in Appendix 1, and places the burden of determining the specific boundaries upon the applicant. It is not the intent of this ordinance to set the specific dimensions of each designated wetlands preservation area. Currently, Appendix 1 generally identifies protection areas near the Atlantic Ocean, but not the areas adjacent to Lake Worth. The text of the Code of Ordinances does refer to Lake Worth Lagoon, and it should be updated in the official map. The purpose of the item before you today is to simply update that existing appendix to one that is consistent with the text and the language that's in this existing ordinance that's already in effect and being enforced by city staff. Before you on the screen is the existing map, which is included in Appendix 1 of the ordinance. It identifies areas on the Atlantic side of North Ocean Drive. And before you on the screen now is the proposed amended Appendix 1 that shows an updated modern map. The primary difference between the existing map and this proposed exhibit is the area along the Lake Worth Lagoon on the west side of North Ocean Boulevard. Again, based on the intent of this existing ordinance, the language and the definitions contained in it, staff has always enforced it based on its intent to the areas of Singer Island on the side of the Lake Worth Lagoon, as well as the side of the Atlantic Ocean. However, when it became apparent to us that there was some confusion based on the map, we took this opportunity to update the map to provide consistency with the text and how it is enforced and intended based on the language that was approved by City Council some years ago when this ordinance was approved. When the existing ordinance was approved. The second change that this ordinance will make is to also update Appendix 2. Appendix 2 contains a list of vegetation that are indicators of the presence of a wetland. The existing Appendix 2 refers to a list that was developed by the Department of Environmental Regulations. That department, since the 90s, has no longer exists. It has morphed into the Department of Environmental Protection. Our proposed amendment for Appendix 2 adopts the existing list for the Florida Department of Environmental Protection for the types and species of vegetation that indicate the presence of a wetland. Staff has received multiple correspondence related to this agenda item via email and phone calls. We have summarized the will of the residents who weighed in via those mechanisms. And in support, we had a total, as of this meeting, we had a total of 32 and 1 in opposition. It did become apparent to staff that there was some misinformation about what this ordinance is. So to clarify, this ordinance is not connected to zoning. It does not change the zoning of any properties in this area. nor the future land use of any properties in this area. It is simply an update to an existing ordinance related to how lands can be developed in and around wetlands. It is not connected to any development proposals. This application is staff initiated. That being, staff believes it's in the best interest of the city and our enforcement of existing rules to clarify this ordinance in this manner. This item before you does not change the enforcement of the existing ordinance. Again, all areas shown on the proposed map are already enforced with the provisions of the Wetlands Ordinance. It does not change how we would process any applications submitted for any lands in that area, because this ordinance, as is, already applies to those lands. We're simply clarifying the exhibit to make that clear. And again, this proposed amendment does not change in any of the text and the substantive information and regulations in the existing Wetlands Ordinance. City staff recommends that the Planning and Zoning Board find that it is reasonable and appropriate for the city to amend the Code of Ordinances, Section 23-83, as described herein, and recommend approval of this ordinance as proposed. And that concludes the staff presentation.
Thank you. At this point, we're going to go into public comments.
Madam Chair?
Yes.
Please speak into the microphone.
Okay,
Thank
thank
you.
you. At this point, we're going to go into public comments. Now, I do have public comment cards as well as documentation on public comments. So, Ms. Savage, I'm going to ask you on the hard copy here, just to make it on record of the in favor, oppose, public comments, and then we'll go directly into the public comment cards that are before me.
Very well. And would you like me to read the names? Is that what you're asking me to do?
Yes,
Okay.
why not?
Very good. So we received comments from the following people. I'll just read the name and then their opinion. Renee Delgado, in favor. Carol Friedman, in favor. Carolyn Keeley, in favor. George DiNardo, in favor. Merle Nidell, in favor. Sally Morris, in favor. David Spots, in favor. Sylvia Clement, in favor. Monica Stein, in favor. Lynn Pasekis, in favor. Anna Verdnig, opposed. Joseph and Lisa Martinez, in favor. Frank Stein, in favor. Diane Alfano, in favor. Bernice Katz, in favor. Diana DeGrosso, in favor. Gail Stein, in favor. Maria and Guillermo Palm, in favor. Melly Lewis, in favor. Jack Fairbrother and Gail Bremer, in favor. Gay Gershoni, in favor. Peter Zobel, in favor. Gary Anderson, in favor. Stephen Nidell, in favor. Carol Boy and Arthur Lawal, in favor. Tony Eddy, in favor. James Kane, in favor. Lolly Fink, in favor. John DiGregorio, in favor. Marisol Bolado and Donald Black, in favor. Jackie Kurtz, in favor. Gary Schnaubach, in favor. And that concludes the list, Madam Chair.
Thank you very much. Okay, now we're going to go into physical public comments. And as your name is called, please say your name and your address here in the city of Riviera Beach or not. And Madam Clerk?
Yes, ma'am.
We're going to have the comments at 3 minutes. You're going to keep account?
The clock is on the screen, Madam Chair.
Okay, thank you. All
You're
righty, good deal. All right, the first person up is Mr. Glenn Spiritus. Welcome.
Welcome. Good evening, Madam Chairman, members of the Planning Board and Zoning Board, city staff. Thank you for the well wishes, by the way. We appreciate that. I'm here speaking tonight on behalf of the Waterglades Condominium associations. We have 256 units that will be impacted by this ordinance. We're within 500 feet of the ordinance project area. We supported the master plan and the amendment to the master plan calling for this area to be an environmental preservation zone. And we definitely support the update that this ordinance does to your map with respect to the vegetation. As you know, the vegetation is very important to the many species that live in this area. As a matter of fact, one independent report by a professor from FAU identified species here that don't exist anywhere else. Also, the manatees feed off of the grasses at the bottom of the lagoon. So we encourage you to vote yes and adopt this ordinance to help preserve the lagoon, Lake Worth Lagoon, and the entire environment around it. I am speaking for the 256 units at the Waterglades condominium, and there are a number of people here from the Connemara and other condominiums, and I can tell you that we all support your vote yes in adopting this ordinance. It's very, very important to the city of Riviera Beach and to the environment as a whole, to the whole state of Florida, and probably the entire United States, and maybe even the whole world. So please vote yes. Thank you for the time today, and thank you for all the good work you've been doing.
Thank you for your comments. Next, we have Carmen Spector.
Hello, thank you for your time, everybody. I'm going to be a resident from Pine Point Drive. My question is for everybody, I guess. I just don't understand how the protected area on the lagoon side is preserved for, for environmental purposes, yet there's been development on that side and electricity put in the ground on that side. On the preserved area, I'm just questioning how that was able to happen, and I don't know if that's appropriate for this meeting at this time, but I just don't understand how that happened and would like clarity on that. Yeah, thank you.
You're welcome. Thank you for your comments. Next, we have Sam Spector.
Good evening, everybody,
Welcome.
and welcome. Thank you for the nice wishes. My concern is, are we having this meeting to really see, to pacify the homeowners and the residents if there's already a plan in place that you're going to adopt? Because sometimes I go to these meetings and they've already agreed to do development in a certain area, and it just makes it like everybody, try to make everybody happy. I hope that you adopt the ability not to build or develop on that property. It's very, very important. I've lived there. I'm 57 years old. I've lived there since I'm 14 years old. I've seen it grow. I've seen it not grow, but it's always beautiful there. And like the gentleman said, there are certain species and fishes. There's a freshwater pond on the lake, on the island, that feeds through there, and we don't want to develop that or build it. We do not, as homeowners, go there and destroy it. We preserve it. We keep it clean. We do everything. So I just want to make sure, if we're having this meeting, it's great, but I also want to make sure that it's not a meeting just to pacify the homeowners. Okay, that's my question.
Okay, thank you for your comments. Next person up is Thane Lozman.
Good evening, Thane Lozman. When you do the Pledge of Allegiance tonight, you said liberty and justice for all. That means people have to be treated equally. Everyone who comes here that lives in a condo in the existing wetland preservation area, I'm going to say they have unclean hands. They built in the wetland preservation area, and now they want no one else to build. So they're putting an overlay on property that me and my friends own. We own 71 acres of property over there. we own, I don't know, a few thousand linear feet along the road. So we own basically the whole west side of North Ocean Drive and all of Pine Point Road to the north. So the point, what you need to think about is, for those of you who live on the west side, this group right here in Singer Island is writing a check that for generations to come will have to be paid for by the west side residents. Because these properties were sold in 1924. They were dry land. Where our property is on the map was dry land. When they widened North Ocean Drive and raised it up, they dredged a channel, and you can see it on the map. And they took that material to build the road. But we had vested rights to develop that property. It wasn't a nature preserve. It had no water on it at all. So we have a right to restore the property, and we have a right to develop the property. Now, if you want to take away the right with all this regulatory overlay, you're going to have to pay for it. You're inverse condemning this property. Okay? There's going to be a legal action filed here in the next month that's going to shake up this city to its core. It's going to be the biggest regulatory taking case in the history of the state of Florida. You cannot come in and take away vested development rights unless you want to eminent domain the property. You're certainly welcome to do this, but you can't take away the rights that were sold in 1924 that these property owners pay taxes on, because the people that built across the street, they got there first and they don't want anybody else to build. But the biggest thing going is we can prove that a criminal act created those lands to be submerged. They weren't submerged when they were sold in 1924. Now, these people are going to come whining here about 5 or 10 years from now and say, our road is flooding. It floods at King's Tide. Rising tides is going to flood the road, because when I bought my property 8 years ago, it was much wider. They're going to come in here, they're going to beg you, like, we have to backfill and fill in these properties to save the road from flooding. The Department of Transportation supports our efforts to develop our property. They say we have to do something about it. So the bottom line is, all you're doing is you're writing a check that your children and grandchildren on the west side are going to have to cash, because for the 50 people here, it's like we got there first and no one else should build. Okay, I have a legal team that won a couple cases at the Supreme Court. I have a legal team that can win this case. You ought to just step aside, leave the status quo. These are tidal coastal areas. These aren't wetlands like marshes or bogs of the Everglades. You've been fed a bag of goods by this development director tonight. Thank you.
Thank you for your comments. That concludes public comments. Mr. Sermon, may I ask you to come to the podium, please? I'll give you a moment. For edification, can you restate the purpose and goal of the meeting in terms of the language that is being presented in terms of staff recommendation, as well as the information on the preserve agriculture, if you will?
Okay. Yes, to restate for the record, the purpose of this ordinance is only to update the exhibits or the appendices related to an existing ordinance. The existing ordinance is already enforced in all areas on the proposed appendix. It does not alter any property rights existing in that area. It does not change how we would process any applications for any landowners that owns property in the areas indicated on these maps. It's important to note as well that the ordinance states that this appendix that includes the map only generally identifies where the wetland areas are. When development is proposed, the burden is upon the property owner or the developer to provide the necessary information via surveys and vegetative information, whether there are any plant life there that indicates it is a wetland. So if development is proposed, the process that would take place does not change based on the amendment in front of you. It only clarifies the exhibit or Appendix 1 attached to it. So I did want to make sure it was clear that this does not alter anyone's property rights. It is a staff-initiated text amendment to clarify the ordinance once it became apparent to us that there was some confusion.
Okay, thank you. And at this point, we're going to go down the road, starting with Mr. Brown, to find out if our board members have any questions. So, Mr. Brown, we're going to start with you with board questions.
Are there any more plans to do any more surveys in the area? This was a desktop survey, right?
And before you answer that, Mr. Sermons, can we put the picture of the proposed wetlands up so we can see it versus the clock?
Yes. And the question was, are there currently any plans for additional surveys in the area?
Yes.
No. At this time, the city has no plans for surveys to be done. The ordinance does make it very clear that the burden is upon the developer to provide surveys that depict any vegetation present in the area, and if that vegetation corresponds with any vegetation in Appendix 2, it is deemed a wetland, and this ordinance then applies in terms of restrictions on where and how you may develop. The city did conduct a review or commission a review by a third-party environmental firm to verify that there are indeed protected resources in this area via vegetation as well as protected species, and that third-party review did confirm that there are various environmental resources that are worthy of being protected in this area. That combined with the intentions of the city's comprehensive plan and our existing language in the Wetlands Ordinance come together to make it clear that it is the will of previous councils and the citizens of the city to protect this area. And again, this ordinance is just clarifying existing regulations that already apply.
Thank you.
You're welcome.
Yes, Mr. Gatlin, board member.
No questions.
Okay, all right. Board member Burgess.
This question is for you, Mr. Sermons. You said that this ordinance is currently in force. So who is the main enforcer within the city that will go out to make sure nothing is developed there without permits and so forth?
So in the event that there is a permit or a site plan proposal for somewhere identified in this ordinance as a potential wetland, when staff reviews it, they will request a survey that includes vegetation in the area. And upon reviewing that survey, that has to be certified by a certified surveyor environmentalist, we verify or determine, based on that survey, if there are any vegetation present in the area indicative of a wetlands. And if that is true, then the rest of this ordinance applies in terms of how and where you can develop near a wetlands. And so it is the staff of development services primarily that leads that review process and requests all relevant information to make that determination.
Okay, besides the paperwork, is there any physical inspection of the area that goes on continuously because the wetland designation?
There is not environmental monitoring that takes place by the city, if that's what you're asking. Almost every time there is proposal for development, just about anywhere in the city, staff does go and lay eyes on that area to verify what we're being told and receive via paperwork in our office and what's actually there on the ground. So in instances where something has been proposed out here, staff absolutely goes out there to take a look to observe what's there. Okay,
last question. Is there currently any signage out in this area denoting anything about the area as far as wetlands proposed? Any signage?
To my knowledge, no. The majority of the area is private property. There are some areas that the city owns, and I believe in the areas where the city owns, where Fire Station 86, for example, there's some signage speaking to the vegetation and wildlife that can be found in wetlands, because the area surrounding Fire Station 86 is one of the designated wetland areas on this map as well. It's important to note as well that the condominiums that do exist on the west side of North Ocean, they are built around those areas indicated as wetlands, and they are preserved via the site plan of those properties on this map. So we are aware of where these areas are, and in some instances there are signage for viewers and passerbyers to understand that it is a wetland, and there are some wildlife resources that can be viewed there.
Okay, thank you.
You're welcome.
As far as the developer goes and providing staff with a survey specifically around the vegetation, we as a city have already done our due diligence, and you've provided the list of vegetation. So really, when a developer provides their survey, it really has to coincide with the vegetation list, for example, and the due diligence the staff has already done. So there isn't any way that they could possibly miss protected vegetation or vegetation in their survey process.
We require that the survey is stamped by a licensed professional, and to a certain extent, for many of the submittals that come to our office, we rely on the integrity of those licensed professionals, because it's understood that if it's determined that they have sent something that was purposely wrong or deceiving to a public entity, that they could lose their license. So in some instances, we are able to go and verify some things that we receive in our office, but we rely heavily on the licensing systems of the state of Florida, that no professional would jeopardize their license by submitting something that's false to the city.
Okay, thank you very much. Board Member Wiley?
Sir, I wanted her to address the question that she spoke of about some, I guess, maintenance. Was it already done on that area? Mm-hmm. Development on that area already? Could you elaborate on that a little bit, please?
There are some instances where there have been structures erected in this area of the city, and the city has responded appropriately in those situations. But part of the need for the passage of this ordinance is to clarify that these areas are subject to the Wetlands Protection Ordinance. There's a certain process that you must go through if you want to develop in those areas, and that's why the city handles applications in that area the way it does. So, yes.
Thank you. And also, legally, as I hear the information here, legally, the city of Riviera Beach is protected by determining a wetland tonight, or what we did before, but at tonight enforcing those rules and regulations. So now the city is protected from, what we're doing tonight is going to protect the city from any possible lawsuits?
Well,
will enforce the lawsuits?
We certainly can't control if someone files a lawsuit, and staff does spend a considerable amount of time responding to lawsuits and depositions and things of that nature. A part of the need for this amendment is to clarify what the regulations are to kind of reduce the amount of lawsuits. But it's possible, but we believe this amendment further insulates the city for any lawsuits, and we do believe it is in the best interest of the city to pass this.
And given that determination and what you just elaborated on, then at that point, will we be to the will of the people in that area who's mostly affected to be able to make that determination also, to at least value their input, correct?
Absolutely. And noted in the staff report is that the previous action that City Council took in this area was to update the zoning to special preservation. During that zone change process, the city received 200+ comments from citizens in the area, fervently in support of protecting the small sliver of natural habitat that remains on Singer Island. So the public from, based on their actions, are overwhelmingly in support of any actions that preserve the vegetation and subsequent wildlife that exists and commutes to this area. So we do believe that the will of the people is for this ordinance to pass.
And when it first came to our board some time ago, I know we had a bunch of phone calls, either in favor or opposed. So I took the liberty to go over and park my vehicle and talk to a few people there just to see what their idea was and the people that was passing by. And people were very strongly against any kind of changes to the wetland. In fact, the father-son duo had jumped out the little raft they were on, and it was like, you know, we don't want any changes, we don't want this, we don't want that, and keep it the way it is, and we want to keep everything preserved. And about 10, 15 other people I spoke to there said pretty much the same thing. So I guess we have to take that into account of, you know, of what we're going to decide tonight, but thank you for your information. Thank you.
Thank you.
Board Member Shepherd?
Mr. Sherman, just trying to clear my mind a little bit. Mr. Sprague. Which item? Is he involved in this? Look like I kind of remember something.
Who's the name you mentioned?
Mr. Sprague.
No, he's our marina consultant, madam.
Okay, I know I heard the name. I was trying to clear my mind up. As the individuals talking about building on the property that they have, just a question. I know you're putting this in place. Will they ever be able to build on that piece of property? Is this going in effect? I'm just asking. This going in effect, it will stop any building over on that piece of land. Is this what the city is reaching for?
And you're referring to the land west of North Ocean Boulevard along
Yes,
the
sir.
lagoon?
Yes, sir.
What I can say is what is definitive in our city ordinances currently. And our comprehensive plan since the late 80s has designated this area of the city as special preservation.
Okay.
And when that was done, it significantly restricted what type of development that can take place in terms of any allowed density or floor area ratio. There is currently none allowed in this area, and that has been in effect since about 1990, give or take. So since then, no density housing units or commercial development have been allowed in this area. The city has taken additional steps to preserve that area by updating the zoning within the last 2 years to be consistent with the future land use. And we are also taking this step right now to update the exhibits related to the Wetlands Ordinance. But the Wetlands Ordinance as well has been in place since 1982, which restricts the construction or demolition of wetlands for development. So these protections have been in place for a long time. I will say that in respect of the property rights of private property owners, there is a savings clause in the comprehensive plan as well as the zoning designation for this area that states that if anyone can prove they have judicially determined vested development rights that owns land there, that they, under very close supervision of the city, are allowed to exercise those property rights. But that means they would have to already had those rights prior to this ordinance going into effect in the 80s. So there is a savings clause for the property rights of any owners who own these properties previous to those times, but otherwise the ordinance of the city are very clear that those areas are targeted for protection and environmental conservation.
Thank you. I know you just got here, and maybe you really don't. I'm sure you know. I just wonder why did the city sell that piece of property?
The city sold a piece of property?
I'm thinking that the individual talking about building on that property that has in their possession this piece of property, if it was going to hurt the wetlands, I'm wondering, well, how did they get the property? The city had to sell it to them.
If I'm not mistaken, the state owned these lands before they went into private hands. To my knowledge, they were never owned by the city of Riviera Beach.
Okay, now you're clearing it up, because I've been following this for a very long time, and I couldn't quite get it because things were rolling very, very fast, and then, of course, everything changed. But I've been in favor of many, many years protecting that area. So it's really nice that now the city's tightening up the loop, that, you know, we understand that these are protected lands, and they should be protected. They're very beautiful. I understand the fish, it's beautiful. Everything is down in the ocean is wonderful. So I'm so happy that you all are tightening up this provision.
And if I may, Madam Chair, I would just add to that all of the items on tonight's agenda are staff initiated.
Understood.
The ordinances of the city should be viewed as a living document, and from time to time, they need to be revisited, updated, and staff's role is to ensure that they're consistent with the current modern developments, and various other things that affect whether ordinances are still appropriate. So staff is taking the initiative to address several areas of the code tonight that just need an update. And this is one of those, and we'll continue to be diligent to make sure the development codes of the city of Riviera Beach facilitate the built environment that we all want to see here in Riviera Beach.
Thank you. And our last board member, Mr. Fernandez.
Mr. Sermons, I'm glad you brought up the 1987 comprehensive plan. That severely restricted what you can build in the area we're discussing tonight. Am I correct?
That's correct.
So if you purchased a property after that date, knowing full well the restrictions on that property and the intent to preserve the area, would you consider that a buyer beware type of scenario?
Mm-hmm. We do recommend that anyone, before they purchase city land in the city of Riviera Beach, that they do their due diligence beforehand to ensure anything that they would like to do on that property is allowed by current ordinances. So, yes.
Another question for you. Some of those lands up there, correct me if I'm wrong, were they purchased by developers who were given development rights in other parts of the state, and they agreed to purchase submerged lands to preserve them? Was there any of those lots included in those type of deals?
That question I cannot answer.
All right. I thank you for your service and your team bringing this to light. And remember, we have a public interest in protecting our wetlands. In the 70s, I don't know if everybody was out here, remember the smog everywhere? We instituted the Clean Water Act in the 70s because there was a public interest. Okay, so we do have to weigh the private and the public, but when the public interest far outweighs that of the private, we really got to consider the public interest. Thank you very much.
Thank you.
Do we have any more questions from our board? Okay, seeing none, I'm going to ask that we make a motion to adopt the recommendation that the staff has presented to us in letter G of their recommendation. May I have a motion, please?
I motion to amend Code of Ordinance, Chapter 23, Sections 23 through 83, updating Appendix 1 and 2 for a recommendation from our wonderful city staff team.
Second.
Madam Clerk, you have the first and the second?
Can I please have the second clarified?
Ms. Shepherd, second.
I second it,
Thank you.
Simone. Ms. Simone, I'm sorry.
Thank you.
May we have a vote count, please?
Anthony Brown,
Yes.
James Gallen,
Yes.
Renee Burgess,
Yes.
William Wiley,
Yes.
Margaret Shepherd,
Yes.
Frank Fernandez,
Yes.
Evelyn Harris Clark.
Yes.
Unanimous vote.
Okay. At this moment, we welcome our visitors if they'd like to stay for any other aspect of our agenda. If not, I'm just going to take a few moments just so everyone can depart, those who are going to leave and those who can stay can come forward in the empty seats. Are you done?
Yeah, we did.
And enjoy. You deserve it.
Yeah, like, oh yeah, I had to.
You're welcome. Happy holidays to you.
And
But thank you.
one that the city hired.
You're welcome. Thank you. Thank you, you too.
Is your mic
Happy
on,
New
Ms.
Year.
Savage? Is your mic on?
My mic is on, yes, Madam Chair. Shall we continue the meeting?
We're going to go ahead and continue the meeting.
Yes, ma'am.
I believe that,
Yeah, that's true.
oh, excuse me.
That's true.
Thank you, ma'am.
Happy holidays.
Thank you.
That's item B.
Thank you. Good night.
Thank you, Madam Chair. The next item under new business.
Just a moment. I'm going to ask that those who would like to stay for the remainder of the meeting, please come forward. Everyone else, if you're going to depart, we're going to ask that you have the conversations in the narthex. We're going to continue on with our agenda.
Thank you, Madam Chair. The next item is item 8B. It's an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending City Code of Ordinances, Chapter 27, Planning, Article 2, Administration, Section 27-31, entitled Created Members, Quorum, Term, Vacancies, Removal, in order to change the title of the section, provide guidance on procedures for appointment of regular and alternate members, establish the number of members and alternate members, and establish general qualifications for board membership, and amending Chapter 27, Planning, Article 2, Administration, Section 27-33, General Duties, by amending the reference to the Planning Board and adding board member participation and training to the list of general duties of the board, providing for applicability, conflicts, severability, and codification, and providing for an effective date. And the board will recall that we have discussed this previously. This is zoning amendment application 2107. So what prompted this amendment to the Land Development Code? The main impetus was a lack of clarity about the process to appoint regular and alternate members to the Planning and Zoning Board. There was also an expressed interest in clarifying the process in which an alternate member moves up to a regular member position on the board. And in reviewing the code at the direction of the Planning Board, actually, we also looked at examples from some other communities in Florida, and since we were going to be modifying this section of the code, we thought that we would take a broader look at it, and so that's where some of the other changes that are proposed are coming from. This draft amendment was workshopped with the Planning and Zoning Board extensively at the meetings of October 28th and November 4th. After the last workshop meeting, the Planning Board directed staff to leave and make some additional amendments to the code, but then more importantly, also dialogue with the City Council members and really take a gauge of their desires and thoughts and opinions on this, because ultimately they are the appointing board for this group. And so what you have in front of you is a revised text, and it's revised based on planning board comments, as well as some direction that we received from the City Council. So the first section is, I'm just going to run through really quickly, really the substantive changes. I know that the board is familiar with this, but please bear with me. The first change is that we're revising the section title as shown. We're also revising the membership numbers. So we're proposing that there would be 5 members and 5 alternate members. Right now, we have 7 members and 2 alternates, so it's a little shift there. We're also proposing to clarify that each council district shall be represented by 1 regular member and 1 alternate member on the planning board. The alternates shall be voting members when they serve at a city planning and zoning board meeting in the absence of a regular member. So what this really does is it reinforces the equal representation throughout the city. We're proposing to revise the language on appointments and, as we said before, kind of clarify the process. So appointments of the regular voting members and the alternate members require an affirmative vote of 3 members of the city council at a regularly scheduled meeting. Each term for city planning and zoning board members will last for a period of 3 years, with the initial appointments having been staggered, designated as groups A, B, and C. Members may be reappointed for subsequent terms. So we do not have a term limit, and as this section says, you don't all have your terms expire at the same time. It's staggered, which is beneficial, of course, for the board. This item formalizes board procedure and governance. This talks about that the members shall elect the chairperson of the board, and that you can adopt reasonable rules of procedure to govern the conduct of business and the holding of hearings. The board shall keep a permanent record of proceedings and shall file approved minutes of each meeting with the city clerk within 30 days of the date of the meeting. All meetings, records, and files of the board shall be open and available to the public. Now, we're saying this in your code, but it's already this way. We're just stating the way that we currently operate. This section of the code has not been updated for quite a long time. This section provides guidance to the City Council in reviewing applications for membership to the Planning Board. So we're trying to provide some guidance, but ultimately the decision is at the discretion of the City Council, of course. So we state, the City Council shall consider the following qualifications when evaluating candidates for appointment to the City Planning and Zoning Board. Candidates must be 1, a resident of the city or own property within the city, and 2, knowledgeable about the community or engaged in civic involvement, and or 3, knowledgeable in the field of comprehensive planning and zoning, this chapter and other applicable regulations. Now, I will note that previously this board had discussed if residency in the city should be a requirement for membership on the board. The text as written right now does not make it a requirement. It says you must be a resident or own property within the city. So, and I know the board was split on that item, so I'm calling out to you that if the board feels that residency in the city of Riviera Beach should be a requirement, you would want to direct staff to edit item D1. Right now, it doesn't require that. This text provides guidance to the City Council for filling vacancies. We state in filling vacancies, the City Council may give preference to currently serving alternate members for that district. We clarify the attendance requirements when basically it states that any board member who fails to attend 3 consecutive regular meetings without cause and without prior notification to the secretary of the board shall automatically forfeit their appointment to serve on the board. The proposed language also includes a general statement about cause for removal and retains the language that already was in there stating that the City Council may remove a member for cause. The proposed language also adds a requirement for a majority vote of the City Council for removal. Finally, the text change establishes participation in training related to the general duties of the Planning and Zoning Board. It adds it to your list of duties and responsibilities as planning board members. Again, this is something that you already do regularly. We're just putting it in writing. So staff recommends that the Planning and Zoning Board approve the amendments to Chapter 27, Sections 27-31 and 27-33, as proposed in application ZA 2107. And that concludes my presentation.
Okay, let me start and open up, and then we'll move down our board line. I am not in total agreement with portion A, and that is the goal was to refine the existing text related to the P&Z board, provide guidance on a process for appointment of regular and alternate memberships for the city council. I agree that the language is outdated and it's not tightened. Therefore, some of the discussions that the council have has had them not coming to any sort of consensus as to how this should be done, because the old language was kind of not really tight. The objective was leveling the playing field for alternates, those who, after dedicating and volunteering their significant amount of time as an alternate, and then eventually would become a voting board member when the next vacancy occurs. The goal was to not to have discouragement or disappointment in being overlooked as an alternate, or it may not be attractive to get people to volunteer and do their civic duty. And I went back into the minutes from that previous meeting, and it was very clear that we had asked, or at least a few of us had asked, and me specifically, my language was not to lose anyone sitting currently on the P&Z board. If the city council chooses the 5-5 board structure to make sure to delineate the language in when the transition would take place upon each member's term of expiration, I didn't see that in any of the documentation, and that was, again, in the minutes that we had talked about. And also, too, it was also to present the city council with an option, and that is to look at our current 7-2 structure, and there shall be a city planning and zoning board which consists of not less than 7 members and 2 alternates who shall be appointed by the city council pretty much in an at-large basis, because we really currently function in an at-large basis, governing body who are elected or appointed to represent a whole municipal population rather than a subset. So that option is not, I didn't see that written in as well. And those were my comments, because it's either to get it right this evening, and I'm okay, especially because if it's the holidays, if staff takes it back and come back to us again. So at this point, I'm going to go ahead down to...
Well, Madam Chair, may I respond?
Sure.
So your first question about how would the transition happen if this code were adopted, as members' terms are up, the city council, just like they do now, would do appointments. So I don't think that if this were adopted, right now you have 7 members and 2 alternates, you're actually short 1 person. So I think the immediate action would be identifying what district, that last person should be. But people that have terms that you're in the middle of the term, I don't think the intent is for everyone to be simply wiped out. You would, as people's terms came up, there would be a natural adjustment.
No, what I'm saying is using the example of how the ordinance was adopted for city council and their term, that there were a couple of city council people at the term that item was going to be put on the a voting block, if you will, that they were grandfathered in. So they were allowed to when their term came up, that immediate action did not take place. They were grandfathered in. So what I'm saying is, if this 5-5 is going to be presented, we here ought to have some process of being grandfathered when our term expired. And then when we have met that criteria of serving, then the next time we come around, then it adhere to this item A. That's what I'm saying. And I don't see that language in here, so I don't want anything presented to City Council and they think that this immediately takes effect. That's not what I want, because I was very clear. I wanted us grandfathered and didn't want anybody on this body left if it was that option. And then the other option was the second one that I just said. That's not even mentioned, and that should be presented to the City Council.
So, two comments. To your first point about grandfathering, you could add a sentence to Section A that says, planning and zoning, regular and alternate members serving at the time of the adoption of this ordinance shall be, allowed to complete their term. I mean, I don't think that that's an issue. To your second point about why didn't we propose options, when you bring forward a code amendment, you bring forward a code amendment, right? There's public notice requirements. You bring forward the language of the code. You don't bring forward two separate code amendments. That's more work, and it's not clear. So the director did talk to every city council member specifically on the points of, should it be 5 and 5? Should they be designated by council districts? And he gauged the opinion of the existing council, and this reflects that. It's not proper, when you propose a regulation, you propose a regulation, and we can edit it, or the city council can edit it. But I don't stand before you and say, we need to do this regulation. Here's two different versions, right? We work on one version, and we amend it to the board's, satisfaction. And that's the way to do the regulation. So we could add a sentence to Section A, if you'd like, regarding the fact, just clarifying the fact that if this were to be adopted, it's not like immediately people are
at this point, prior
gone.
to, we did not have a temperature read of council. So now we have a temperature read of council, and you have provided this item A as a temperature read of council, which we didn't have the first two times that we discussed it. But Mr. Sermons, before we go, I'd like to have the board put in their feedback.
Absolutely.
And you guys just have your ears open as well as ours. So I'm going to go ahead and start with Board Member Brown.
The verbiage and the format seems fine. I had a problem with item A also, which I still do. I still don't agree with it, but if that's what the council wants, then we vote on that.
With regard to the representation, you mean?
The district.
The district, correct, right, that was a debate.
Yeah.
Yes, sir. My understanding is that the city council felt that the district representation was the desirable way to go, and so that's why this reflects that.
Ms. Savage, when did they have that discussion?
So I would defer to Mr. Sermons.
Okay. And then we'll go to Board Member Mr. Brown, Mr. Gatlin.
Good evening again, Madam Chair. Again, for the record, Clarence Sermons, Director of Development Services. Since the last time this item was before you, staff reached out to each individual council member to apprise them of discussions that were taking place regarding this item to get a feel of what direction they wanted this to go in. Again, this initiated from council. This is before you because council deemed it necessary. The last 2, maybe 3 times board appointments were made for the Planning and Zoning Board. There was confusion among city council members, and staff was directed to formulate an ordinance to clarify what the process will be. And so staff is bringing this before you at the request of city council And so the document before you reflects what they have communicated to staff in the direction of what they want to see for the process. Now, of course, there's a public hearing involved. Of course, when this item is before them, there are still opportunities for them to make changes and adjustments and additional public input. But the item before you is reflective of those conversations at previous city council meetings and staff communicating the progress on this item that they requested and what direction it was going so far. And they gave preliminary feedback, and this item reflects those multiple conversations.
Okay, Mr. Gallo?
Item D, number one, I still feel that the appointee must be a resident of the city. As far as owning a property, I would say no, because we have a lot of property owners that does not live in the city. So I think that should be removed or either restated, but I say that they must be a resident of the city. That's all I have.
Board Member Burgess?
I second that. I was just waiting. Yes, please strike or own property. Pretty soon, probably half the city is going to be owned by development. So, no, you can't hold a position on city council, I believe, if you're not a resident. So why should you be able to sit on this board just because you own property here? That's not a vested interest in this community. So, yes, must be a resident of the city. Live here and reside. Those are my comments.
Mr. Wiley?
Yes, I pretty much stand firm on what we spoke of last time about it going from 7 to 5 members and 5 alternates. That's something with my experience in managing 2 organizations that I don't think that's a good idea to be able to do that. I think it's fine the way it is, and I don't think that should change. I also agree with for D, when it says the resident should be a resident of the city. And I agree also with the own property. And I think that kind of is very subjective because it kind of depends, because we do have people here who have owned property for years and may not live in the city, but are born and raised in the city. But that kind of opens up and makes it very subjective. So I agree with the resident should be a resident of the city. But one thing I was thinking about also, that with the city shall consider the following qualifications. And I think one of the issues that we have here in the city is we have on here the knowledge about the community and engaged in civic involvement, and knowledgeable in the field of comprehensive planning and zoning. But at any point, are we going to start vetting people for background checks, financial checks, a resume verification, criminal records? I think something like that should also be vetted also with coming into the city, because if we want to create a better Riviera Beach, we have to make sure that we have the right people inside our city with the right intentions. So I think that's something that we should at least have a conversation about, because again, we want people who are going to represent the city in the right way. And back to A again, about the voting members. So what happens in a situation to where we adopt this plan and we have 7 voting members now, and now we go to 5 voting members? Given that majority of us are actually recruited or asked to apply by people outside of our district, so now what do we do now when we make these changes? Who does what? Are we going to have people who are going to lose their voting rights and now going to be pushed to an alternate? And how is that decided? Or is that decided by the district person in council? Or what is the plan for doing that? And how are we going to proceed from there if we're not going to be grandfathered in?
That's a good question. The city council ultimately is in charge of the planning board. So with regard, if there was questions about voting members versus alternates, I would defer to them. That certainly would be above my pay grade. I would, I serve them. So From my perspective, you have 9 people now. This is proposing a 10-member group. So from where I am, you have 1 more seat to fill. And the alternates don't lose their vote. They can certainly participate. They may not be voting at a meeting. But it would be up to the city council, and I think that's a good question for their public hearing is, you know, are they going to make that, you know, decision if it came down to it?
Because at the end of the day, I feel that the city council should not have that kind of representation to the city, because when the people here vote, we don't vote for a specific district. We vote for everyone. And we vote for everyone to come in for District 1, 2, 3, 4, and 5. And we don't separate that vote. And at the same time, I think the people that we're putting on this board, that we want to put on this board, will not represent a certain area, but represent the city in its entirety. Because that's the whole thing of reimagine Riviera Beach. We're trying to bring everyone together and be able to do the right things in the city. So at the same time, we want to bring in people, the best. I think myself and Mr. Brown talked about it. Mr. Gallen talked about it earlier. Not talked about it earlier, but last meeting, about we think that the best candidate should be the one who should get the position rather than the person who just lives in that district. Because how is the city going to get any better, or is going to come up with great ideas if we're taking the best candidates and we're not putting them in because they live in the same area as another candidate? Or maybe 2 or 3 candidates may live in that area, and all of a sudden we don't have these people knowledge and experience to be able to make our city what it should be. So that's one of my main concerns with that is I don't think that the city council should have a district representation, because we all live, I think, how to say this correctly, Singer Island has a different base, I understand, because I wouldn't know anything about Singer Island besides when I drive over, but I wouldn't know anything about the layout. But I do know my area, and I do have family in every part over in the on the west side. So that would be a little different concept. So I understand that Singer Island will have to have some type of representation to be able to understand what's going on and understand what the people are and everything. I get that part. That's what makes the city a little special. But at the same time, I think that we should still have the best candidates from in the city, period, on the planning and zoning board, no matter where they are, no matter where district they live in. That's my opinion.
So that's a good point, and I will just say for the board, ultimately, if there's items in here that this board is divided on, you know, you don't agree on certain items, if the item advances to city council, I think staff's report would be calling out, for example, item A. You know, the planning, and I don't know what the planning board's position would be, but on something that you didn't have consensus on, staff's report to the city council would have to call it out. The planning board was divided on this item, and here's why. Ultimately, it will be up to the city council to decide, because this article is about how they act. So, but it's our job to call out to them your thoughts, and when they're unanimous, that's what we do, and if they aren't unanimous, that's what we'll do. We take no, you know, we don't vote.
One more question. City council. We spoke earlier, and I looked on here and I saw the word shall, and it said, spoke of city council. I still say in my thoughts that the alternate who have been in for years should automatically be put into, not decision of the city council. Now, again, if this is implemented, I still think that if they have to choose the alternate, that's fine, but the alternate that's in place already should automatically, that shouldn't have to go to board for that. They should automatically be moved into that voting position rather than someone being leapfrogged in that situation because that the person in that district wants another person, and that person who's been giving faithful service to our city now is going to feel very unenthusiastic about representing the city if they're going to keep getting taken advantage of.
So for item E then, is it your wish that in item E, where it says infilling vacancies, the city council, it currently says may, And are you saying that you wanted to go back to saying shall, the city council shall
No, I
give
think it should
preference?
automatically, whatever verbiage we have to use at that point, it shouldn't be left up to the city council to be able to make that decision. That person who is the alternate should automatically go into that position, and then the alternate, they should be able to choose the alternate that's replacing that position. They should be able to choose the alternate for the new person coming in. But the person who was the alternate at that time, if we go to this forum, then I think that that person should automatically, with the years that they've put into the community, they should automatically be put into voting rights.
Technically, the city council would have to vote to appoint them, but we can change language to say that in filling vacancies, because what you're talking about is a regular member leaves, there's a vacancy. If there's a sitting alternate, that sitting alternate should be the person that's advanced, but that does require a vote of the city council.
Right.
Because it's an appointment to the Planning and Zoning Board. So the way to express that would to say, the city council shall give preference to currently serving alternate members for that district.
I just wanted to be fair to the person who was sitting on council, sitting on Planning and Zoning Board and learning, absorbing experience and becoming better, and then I want them to have the right opportunity to be able to serve for the Planning and Zoning Board. Also, when we said about the council giving cause for removal, what specifically would be deemed cause? And then would it be a certain situation where if something happened, would there be 'cause I think someone spoke on it at the last meeting, if something happened, would there be a review board? Would somebody be able to discuss this and to be able to find out what would be the severity of something that happened? And would that person be removed then at that point? And what would deem cause?
So that's a great question. So the first part is that the code currently already has language that says the city council may remove any member for cause. The code, that's already in there. That's existing language. That is not new. What staff has proposed is G, and this you saw last time, any act or omission by a board member which constitutes a breach of the board member's duty to perform the functions of the office, any disruption of the business of the board, a failure to comply with the rulings of the chairman or presiding officer of the board, the infliction of verbal or physical abuse on the other members of the board, city officials or persons appearing before the board, a failure to carry out the directives of the city council, or the commission of misdemeanors, misfeasance, or other unlawful acts, whether or not related to the office, shall be deemed cause for removal. So that's a pretty broad statement there. We just tried to clarify it. Now, one of my colleagues had inserted language in a previous draft that was longer than the actual existing code that kind of laid out this whole process for judge and jury. And ultimately, we deleted that from the final version for a couple of reasons. One, the intent of this article as directed by the city council is to clarify appointment process for the planning board. You know, that was our charge to begin with. And it seemed unwieldy to have this whole kind of judge and jury procedure about removing a planning board member that was larger than the actual article that we were directed to do. And ultimately, in discussing it internally, the city council has the right to appoint people to the planning board and remove people from the planning board. I am a relative newcomer, but I'm not aware of the city council, arbitrarily removing people from service. I know that they're grateful for the time that you put in and the good work that you do. So we ultimately took out that big arbitration kind of process because it just seemed like it would create, I don't want to say a public spectacle, but if there's some kind of disagreement and it's centering around misfeasance or something unlawful, the board has the right to remove someone. So we did take that process out, that long section saying we'll do hearings and this and that. So basically, if the city council wants to appoint someone, they vote to appoint someone. If they want to invoke Section G and there's some kind of critical failure in ethics or action, they could invoke Section G and remove someone, but it's ultimately their purview. So that's why we took that part of it out.
Thank you.
Board Member Shepherd?
Mr. Sherman, could you come to the mic for one minute? I always have to refresh my memory. But I think you, during the last appointments, how you kind of stuck to your guns about the provisions here. But, and I'm very mindful of where I'm at. I've been doing this a long time. And because when I came back from West Palm Beach to Riviera Beach, I think I set out maybe a year, maybe two. And I was appointed by a council person, and a couple of the board members were here. They were here maybe 2 or 3 years when I was gone, but they automatically removed them and put myself and another person. And I just come to the conclusion, and maybe you can clarify it, because I think a new council is coming aboard. I just have this feeling, or maybe a member, I'm not sure. How do you stop that process? How are you going to stop the process? If a new set of people come in, let's just say a new set will come, and they decide they want their person that they trust on the board, how are you going to, you did it well, the other members, but I've seen it done a couple of times.
And the question, to make sure I understand it, is how would we prevent newly elected council members from appointing persons other than who is serving now?
Yes, when the people time is up, if they move them away and they put their people in there. And it's been done a couple of times. And I know I was one of the ones that they moved away, put me in, and another individual. And I'm just mindful who I am. They're council. I feel like they have a right to do whatever they want. Do we question them this time around? Just something to think about.
Yes, I believe I understand the question. We have, through this amendment, put some guidance in here on things that are important to consider when City Council is making appointments to this board. It does not, however, remove the fact that members of the Planning and Zoning Board are political appointees. And when politics change, seated council members change, it is a possibility that members of this board could change as well. And serving at the direction of City Council, the purpose of this amendment isn't to create an ordinance that puts a bunch of shackles on the elected officials on who they can and cannot appoint during their political appointment process. It's to provide clarity to the process, some fairness to the process, because some council members currently are able to elect 3 seats, and another council person is not allowed to elect anyone to any of these seats. So the intent that we were directed to satisfy is to create some clarity in the process, some fairness amongst the council persons, and we've taken some liberties to add some additional things that we believe will improve the process, such as giving them some guidelines on the types of things they need to consider when appointing a person. But at the end of the day, these are political appointees, and we don't believe ordinance, and even from our conversations, staff's conversations, we don't believe there's support for an ordinance that provides a lot of shackles and bounds City Council on what they can and cannot do with the political appointment process, because that was not the intention.
Can you go back to what you said? You're not going to put shackles on council?
Correct. If we bring forth an ordinance that creates a lot of restraints, such as the removal process, saying this is when you can and cannot remove someone, or when there's a vacancy, this is who you can appoint, or you're not allowed to do this. That wasn't the spirit of the request that was made from council. So staff has prepared an ordinance that meets the spirit of what they've requested, taking in account all of the feedback from this board and from them, and we are bringing forth what we believe meets with balance the interests of both parties. But again, at the end of the day, it is the council's right to appoint persons to this body.
Another thing that I think where we really get confused at, we have the districts.
Mm-hmm.
And at one time, I think it was like 4 people from District 1. I think now, before you got here. Never had 2 people from the island. How do you get around that? Because you have council people, I'm saying, if someone come in different and they want to put their person in there. I've lost my train of thought now. I'm trying to figure out how you do it.
I believe I follow your question in ensuring that all of the representation doesn't come from a single district of the city and that it's equitable in terms of representation on this board? Is that where you're going?
I think what I'm saying is that if a new council come on,
mm-hmm.
and they have their people, and you already have the board already in place, and you have 1, 2, 3 in one district, and they want to put, just like I think what happened with Dr. Wotell, because you don't have representation from District 5. And then someone made a comment that the mayor should have privilege of I'm just throwing it out. I'm just trying to get a clear picture of what was said the night I was here. I think I heard someone say that the mayor should have a voice, because right now, District 5 does not, and they're for the whole city.
That's correct.
And I don't think we quite figured it out. Maybe you figured it out, I haven't.
Well,
I'm confused on how we're gonna transact when, like me, I'm up. You know, does my council person want to keep me? She could remove me.
The way we believe that is naturally addressed is that the current system is based on districts, and each elected official represents the constituents of that district. So when they appoint someone, they presumably understand that they're in office to represent that group, and when they appoint someone to this board, that it would be someone that they can trust, would reflect the interest of their constituents. And that's why the rotation of who gets to appoint the vacancies on this board, they rotate through the different elected officials, except for District 5. And again, that's something we're trying to correct through this amendment. But in trusting that council person understands their constituency, that they would appoint someone that would represent the interests of that constituency. Now, of course, we can't control so to speak, who they recommend, but the fact that each council person is responsible for making a recommendation for appointment, we believe addresses the need for there to be representation from all the different districts, so we don't have all persons from one district representing the entire planning and zoning board, or all persons from District 4 or District 2 on this board, but that it be spread out based on those elected officials who are represented or elected by the different districts make the recommendations, if that gets to your question.
Okay, because what I'm alluding to is my council person did not appoint me. I came with another council person, and then I did not know, I really did not know I was in this district until someone from Public Works told me where I was at, and I'm like, no, I don't think so. I'm in Snow, Ms. Shepherd, you're here. And then when my council person was reading it, she's going from my history from 1, 3, now 2. So she's confused, and then I began to explain just what happened. I didn't know where I was at. When they appointed me, they left. So, you know, she...
And to respond to that, that's precisely why we need an ordinance that does what this does, because council had the same questions, such as I can't remember appointing a person to the board. When is my turn, or what seats are to who? And the Development Services staff does keep a roster of these items, but that only goes back so far. It's not in the ordinance. So as far as we can tell, this is how things have been done traditionally for, maybe the last 5 to 10 years, but there's nothing in our ordinance that clarifies exactly how this process shall take place. And so the process that has been handed down, we know there's some deficiencies there. It's not clear, which council members appoint which seats unless they come and see our staff papers that are in a file drawer somewhere. So we want that to be reflected in the ordinance, what council member is responsible for what seats, make it clear what their appointal process is, and also making it clear that we believe it is a fair system that each council person elects the voting member, and they also get the opportunity to recommend their alternate position. So in fairness, when that alternate has an opportunity to move up, the person in that district can make that decision and make sure they're fair to anyone that their district has put in that place and give them the opportunity to move up.
Well, thank you for clarifying some of it. It's been kind of like a mystery, being in a cloud and not really understanding the thought process, I think, when a new council come in and being stuck with us when they really want to have someone else. And I think that's why they kind of go over and pick whom they want to pick. But I hope this ordinance goes through so we will never, ever be stuck in the position again like we have been in the last few years. So thank you, and thank you for your staff for working on this. Thank you so much.
Thank you. Yes, staff has worked very hard to try to incorporate all the points of view into this ordinance.
Thank you.
Mr. Sermon, just real quick on this. I agree it should be a resident. So I believe the majority of the board agrees that it should be a resident and not a property owner. So that probably would be an easy one to amend as we speak.
And I know Ms. Savage has been taking notes as everyone has spoken, so I believe we can make a text amendment, a text adjustment from the floor to ensure that what's voted on tonight reflects what is clearly the majority's will on that item.
Now, going back to A, I understand and I believe in each district council person should be able to select their voting member and their alternate. But according to the way this is written, it doesn't say that that district person can recommend their choice to the city council. All it says is that each council district shall be represented by one regular member and one alternate member. So we want to make sure that the council person has a right to select their individual and propose their individual to the city council for their final vote.
So after PZB, would you add in as recommended by the seated council member for that
Right.
district?
City council for that district makes a recommendation to the council. In other words, like Mr. Sermons alluded to, and we've already I mentioned this in prior meetings, the citizens of that district voted for that individual, so that council person should have the right to select who they want to serve as a voting member and as an alternate. And I understand my wonderful board members who've been on here a lot more years than I have and lived through a couple of eras where things were up in the air. But the bottom line is that we discussed, this is political. It's the same thing happens on the county level, the state level, the federal level. When you got a new government coming in, whether it be Republican or Democrat, they bring their own people in. Yep. And they don't like to be shackled, and we shouldn't be writing any ordinances which shackle our city ordinance, our city council. So, again, they're going to have the ultimate vote on this. I thought by the time we got this back, they would have said, no, we want resident, we want this, we want this, we want this. That way we don't have to discuss it yet again. Yes. Because they're the ones that are going to be voting on it. So I was hoping when I saw it that I would be like, oh, great, here we go, back to, it looks like we're back to square one. So, you know what? They're going to be voting on it. They're going to be making the ultimate decision. So they're gonna leave it up to that council person to select who they want, to recommend it to the city council. Let's leave some of the requirements in here. I was the one that addressed the due process and for cause, because you just can't say, Ms. Shepard, out, you're out. Why? I don't know, I didn't like the way your Slurpee was the other day. I'm just making up some silliness, but you should have a right for due process, and that should be written somewhere in the city charter, that if you fire anybody, they have a right to due process, whether they're union or non-union. Because it's my name, my reputation. If you're going to accuse me of something, I want to know. I want to be able to say, why am I being released? Now, it won't happen here. We got a great board here, but remember, whatever we do here, we're setting it for the future. We're setting a precedent for the future. So we got to be really conscientious of what we do and how we do it. Because like I said, we love it. I'm not in favor of going back to 5. I like the setup that we have here. Because if we have 10, and all 10 are going to be speaking at a meeting, after me, there'll be 4 more that are going to be speaking. We'll be here till after midnight, 1 a.m., maybe 3 a.m. if we're lucky. So we got to, adding 5 more alternates, I mean, man, I don't know why, we should just keep it at 7. And the way we have it now, we speak, imagine, I finish, and then after me, you got 5 more. Hold on, we'll be here till like 2 a.m. So, again, I appreciate everything you've done. I think we've all basically said the same thing and in different ways, but, we serve at the entire city. So it's correct. We serve the city. We don't have special interest.
Right.
However, we should allow that council person to select, so that way every city, every district is represented. Otherwise, in major cities, if you don't have representation in planning and zoning, when that waste management firm comes up and they're looking for a place to plop their waste management location, and you don't have a representative, that won't happen here because they don't want to, but that's happened.
Okay.
And you know where those places are going to end up. So every district should be representative. But the numbers here just don't. But again, I would have just thrown this back to city council, have them decide, and they come back to us. This is what we want after the discussion, and then we look over it. We give a suggestion or two, and then we send it back. But now it's like we're going back and forth, back and forth.
So this won't, the way a text amendment works is that this board reviews it, and then it goes to the city council, and they vote. It's a public hearing. It's a duly noticed public hearing. The director did speak to every city council member. We did not have it as a hearing item on their agenda, because ultimately, it's going to be a public hearing item on their agenda. So we gauged the sentiment of the board individually with direct personal conversations. This reflects that. So the way the process is this board amends it, changes it, gives recommendations. It goes to the city council. If they want to keep it at 7 and 2, they'll strike language and keep it at 7 and 2. If they want it at 5 and 5, they'll keep it at 5 and 5. But ultimately, when it goes to city council, they will vote, and then that will be what the language is. It's not that they amend it, then it comes back to you to bless it to go back to them.
Ms. Savage, we're clear on that.
Okay.
I think my position is that we understand that city council is going to vote and decide how city council is going to. My position is I just did not want to be complicit in not going through this and be a bump on a log without them understanding or having an idea of at least how I felt. And maybe other board members would like to say that I don't want to be complicit in my own demise. I want to be able to say what I have to say, understanding that they're going to vote how they're going to vote. Also, too, for me, again, I'm divided on A. I'm also divided on D1. And I've already shared why I was divided on A. And on D, where it says own property within the city. We have and have had city council people who are members as city council members, and they don't live in our city, but they own property, and they are here to vote it in, and they make decisions. And my saying or own property is to coincide with the same language that is in our ordinance now as it relates to city council people. Matter of fact, it even goes towards the mayor. We've had that type of elected official that did not live in a city but governed our city. So if we're going to be fair, you make it the same way that it is for elected officials, whether they're council members or whether they're the mayor, that they really should be living in our city if they're going to govern our city. But it's not like that. So that's why I disagree, and I'm divided on number one. If it was that they all lived in our city, I wouldn't have a problem with it. But that's not our landscape today. So I think it should, one, coincide with the same ordinance that's on the books that reflects how it is with these elected officials now. So I'm divided on that, and that's why.
That's a good point, and as I said to the board before, certainly they're going to review this and change it as they will. I can advance it with both of that language in there, and in the staff report, I can reflect the fact that the board was divided on that item, or I would probably say the board didn't have consensus on, a certain section of it, and let the council be the final arbiter. So I defer to you if you would want it to have both in it, which you just said that you did, and we can not strike it. It's the pleasure of this board.
Madam Chair?
Yes.
I don't want to prolong the issue, but as I was sitting here and we were discussing the resident versus owning property, I did go to the internet and try to find out what the qualifications and requirements are for Riviera Beach City Council. And I did find one document, which it's not dated, so I don't know how current it is, but it does state how to become a Riviera Beach candidate. And under qualifications, it says 1, must be a U.S. citizen, 2, must reside in the city of Riviera Beach and be a registered voter, and 3, must have resided in the applicable district 1 year prior to the qualifying date. And then it gives the applicable Article 2, Section 1B for the city charter. So, and then the other items are just forms, qualifying requirements that have to be submitted. So I don't see where, it states in here to be a candidate that you don't have to be a resident. But I would say the same. Like Mr. Wiley brought up different things as far as background checks. I mean, I'm not in agreement with making more qualifications for this board that a candidate, an elected official, is not held to as well. You can't have higher standards for a P&Z board than what you have for your elected official. And that's not a requirement. They don't have to do a criminal background check, a credit check. So just if we keep those things in mind, but if you could either verify that if a Riviera Beach council person is required to be a city resident, because what I'm looking at states that they have to reside in the city of Riviera Beach and be a registered voter.
Madam Chair. So Vice Chair is correct. That is a provision of Section 1, and it's Section B, which says only electors of the city who have resided continuously in the city for 1 year preceding the date of filing for office shall be eligible to hold office of mayor or council person, except that the candidates for districts 1, 2, 3, and 4 must reside within the respective district for the required 1 year period. So you're absolutely correct. That is a requirement.
Okay, thank you.
You're welcome.
So at this point, are we taking a vote, or do you just got our feedback and just take it back to council?
Well, the item would move forward to the city council after the planning board. Ideally, we would have a recommendation for you, either in favor, ideally in favor, but but it would go on to the city council ultimately, even if you were deadlocked. I would like to report to them the will of the board, and well, or Mr. Sermons will.
That's what I'm asking, the will of the board. Do you want some sort of vote, or do you have enough to take back? What is it that you want in terms of the will of the board?
If somebody made a motion and seconded, it would be good to have action on the item. Is the board?
Yeah, but what are we voting on? We made some changes to the word, to the paper, so it's, what are we gonna be voting on? The changes you're adopted today, which we don't know because I can't read what you were writing? I mean,
So do you want, so the board is saying that you want us to advance it to the city council and document where the board did not have agreement?
Yeah.
Versus voting.
We can write a detailed staff report.
I'm in agreement with that, because we still have a few people that still have some quandary of, so I'm okay with that. So I think that's your charge.
Madam,
Okay, I'll wait till the minutes come, and then I'll write the staff report from the minutes, just for equity purposes.
okay, seems fair.
I got one more question. Like I said, again, I hate to prolong it, but I want to make sure we get this correct. As he spoke of earlier, Mr. Fernandez spoke of earlier, is it going to work as if council will select someone and then it will go towards a vote with city council at that time, with the entire city council, to vote on that person? Because what if that person wants to bring in someone and the other city council members don't think that person should be on the planning and zoning board? And what happens then?
Ultimately, it's, that's something for the city council to work
Okay, they're
out.
gonna-
Ultimately, if you're on a board and you're advancing someone, you talk amongst each other, people explain why. There's actually an application form for service, and they do some vetting. So that's between them. I
Okay.
can't arbiter that.
Okay, and one other thing, I know through a process that some of us came in on, and it's just a suggestion that when they did the voting process, let's say, for example, we had 3 or 4 planning and zoning board positions available. And then let's say that we had about 10 people apply for it, right? And then those applications will be, looked at, resumes will be looked at and decided upon. And then the voting process that we used for us coming in was, and I think it was something they just adopted for that meeting, was that they picked one person who they liked, and they got 5 points for that. The second person got 4, third person got 3, so on and so forth. And then at that point, they totaled them all up, and the person who had the highest amount of points was automatically put on the board, then the second person, the third person, so on and so forth. And then that way we get an unbiased, qualified candidate into our system rather than a friend or a buddy that may not be as beneficial to the
When
city.
did that happen?
That happened with me.
They had
Yes.
explain it again?
Myself.
They had,
They had a voting process to where
how many people we talking about?
it was, I think it was 4 open positions, because we hired two permanents and 2 alternates that night. And myself and Mr. Hunt, God bless him, were brought in under that process to where they voted. They had our resumes, they had our information, and they voted on us by giving us numbers. And then the highest 2 numbers were voted in that night, and then they made a decision on the next 2 for alternates.
And that's a good point. I think with the language here, if the council chooses go to district representation, then ultimately that's what will be driving it. And if there's a vacancy in District 2, then that council person will be making recommendations. I mean, applications for service will come in, but when there's a vacancy, I would think that each council person would probably give some deference to their colleagues, because when their time to appoint someone is up, they want their colleagues to work with them. So it wouldn't be a majority vote kind of, district blind process that you went through. But again, right now we have a process where not all districts are represented equally, and we've been directed to try to rectify that moving forward. And so we're following the direction of the council.
I think the one thing I wanted to do was make city council's job a little easier. And to me, this seems to be putting in city council in the day-to-day operations, and which they shouldn't be, because that's the reason why the planning and zoning board is here, to make the job easier for them. If they have to get to the point where they're making decisions on human resources and hiring police officers and everything, what's to stop at this point to where you're bringing in the type people, like Mr. Fernandez said, you're just bringing in your people into your into the organization rather than go through the proper process or have an unbiased process.
I hear your perspective.
I'm just, like I said, in the
mean,
process of
Ultimately,
managing.
it's a political process. I mean, I hear what you're
That's what I
saying,
hate.
but
Yeah,
it's a
I
political
understand.
process.
It is.
And the city council already has the authority to appoint, so
It is. I like you, so I appoint you.
so I hear you, but,
That's a good one.
so based on, Madam Chair, is the direction of the board that staff receive the minutes and write a detailed staff report about where there was points made on, and then advance the language?
Sure, and I again, on that item 1 of D, and I've heard what our attorney has said. I'm just saying that it's written like that, but in actuality, that's not even how it happens.
That's
Do
a
we know-
violation.
Yeah.
Well, you know what, it's like that.
It's not uphill.
Where they gonna sit?
It's not uphill.
Like that. I remember it being a huge discussion
Even
a
when we-
long time ago.
Even when we look at G, that's not being uphill at all, so.
Okay, so I think you have your charge, and let's go on to our last item, or unless I take a vote from our board and find out if we want to table it to
No.
next meeting.
Let's move on.
Move on?
Yeah, let's
I'll be
move on.
quick,
Okay.
I promise.
City Council has adopted rules of decorum for public comment to include a 7:30 time certain, and your agenda is not in accordance with public comment. That you should have, with the rules of decorum are posted at the front of the council chambers, and it should be 7:30 time certain or when the last agenda item.
Generally, the way that we've always been running the meetings since I've been here is that we did not wait until the last moment with public comments, and the business has been taken care of, and it became a disadvantage to the guests that were here that they never had an opportunity to speak. So, just one moment. So we try to give public comments right after staff or the applicant give their presentation, and people give their public comments where it's applicable at that time. But I don't want to be remiss that you have a public comment in, and we can go ahead and take that.
You need to be on microphone.
Just a regular.
He wants to speak under public comment, section 10A.
Sure, okay, and if we miss that, usually I'm advised, but we missed that, I apologize.
We did not miss that, we're not there yet.
We're not there yet?
there yet.
Oh, okay, all right, good, okay.
That's under general discussion.
Okay, so we're not there yet. Okay.
I
So we're
will
under-
move quickly through this material. I know the board has reviewed it, so I will move quickly through it, and if you're ready.
Of course, yeah, we're
Okay,
ready.
very good. Mr. Walter, could I have the other one up, please? So the next item before us is an ordinance of the City Council of the City of...
Let me just look at
Madam Chair, please
Just-
let him speak so we can move on.
Just one
Madam
moment,
Chair.
Let him
everybody.
speak.
Comment on what?
Just, well, I'm going to ask just one moment, please.
Just let him do it.
Okay, so we have item B we just covered, we're on item C, then we go to workshop items, and then we go into general discussion, and then we go into public comments. That's the way the agenda is outlined right now. And you know what? We're going to move on with item C. Ms. Savage, go ahead, move on, and we're going to follow the agenda. We're going to follow the agenda. Go ahead, proceed, Ms. Savage.
Thank you, ma'am. I'll be quick. So item C is an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending City Code of Ordinances, Chapter 31, Zoning, Article 5, District Regulations, Section 31-483, Minimum Site Area, in order to allow land outside the Inlet Harbor Center redevelopment area to be included in the minimum site area for an IHC PUD, and amending Chapter 31 zoning, Article 5, District Regulations, Section 31-497, Property Development Standards for the Inlet Harbor Center Planned Unit Development IHC PUD to establish a maximum height of 20 stories or 200 feet for new IHC PUD projects, and amending Chapter 31 zoning, Article 5, District Regulations, Section 31-534, downtown districts generally, to allow new Inlet Harbor Center planned unit developments within the CRA, and correcting 2 typographical errors, providing for applicability, conflicts, severability, and codification, and providing for an effective date. So this is zoning amendment 2108. Now, what prompted this zoning amendment? The zoning division of the Development Services Department prepared this proposed amendment to the Code of Ordinances in order to provide a thoughtful mechanism for higher density development within the CRA and on adjacent properties if they are developed as part of a planned unit development. The need for the code revision has been highlighted by increased development pressure within the city. The CRA supports this proposal, and a copy of the memorandum from the CRA is included in your backup material for your reference. Very briefly, this proposal is to revise 3 sections of the Land Development Code as follows. Chapter 31, Section 31-483, maximum site area. The intent of this revision is to allow land outside of the Inlet Harbor Center redevelopment area to be included in the minimum site area for an IHC PUD. Now, before I go any further, the Inlet Harbor Center redevelopment area, it's now called the CRA.
Okay.
And so that language is old. One of the other changes that is not called out in your PowerPoint, but that we would make if this advances, is to actually do a search and replace the IHC redevelopment area with the CRA. So that we look at that as a housekeeping item. But again, the CRA is where the city in your guidance documents has said this is where we want some higher density, walkable, pedestrian scale development. And this is to allow somebody, if you're within the CRA, say you own 5 properties in the CRA, and your property, maybe 2 of them are outside the CRA and 3 of them are in. Right now, if you wanted to come in and do a planned unit development, the property that's outside the CRA, you couldn't actually develop in accordance with, your master development. In other words, it's like a wall is at the CRA boundary. And staff's discussion internally and with CRA is to say, if somebody is bringing forward a thoughtful development, we should not preclude them from proper design simply because some of the property may fall out of the CRA. So right now our code says if you're in the CRA, you could develop it. If you're outside the CRA, different zoning rules apply. So we think this is a reasonable accommodation. The next proposed revision is to Chapter 31, Section 31-497, Property Development Standards for the IHC Planned Unit Development. So the intent is to establish a maximum height of 200 feet or 20 stories for new IHC PUDs. And again, backing up, Marina Grande was developed as an IHC PUD. I believe they're 25 stories. After the Marina Grande, and this is well before my time, so Ms. Shepherd can certainly correct me, but after the Marina Grande, PUDs, the regulations were changed to say, in 1983, no new PUDs in the CRA. And my understanding is when that downtown code came in, that restriction was put in place because at the time, there was a desire to control kind of some unchecked development, right? That was prior to the recession, and the people that were in power at the time thoughtfully put in that provision to say, no new PUDs within the downtown district. Well, now, fast forward to 2021, Our leaders, our regulating documents, even our comprehensive plan, the CRA development plan, all say that we would like to have some higher density development with, walkable pedestrian scale economic development within the CRA near the water. And so, and there is certainly interest in that, right? You have Nautilus right across the boundary. We have proposals that this board has been hearing about, within the CRA. And so staff has been thinking about the will of the council and people that are saying, gee, we should have some of that higher density development, but we don't want it everywhere in the city. We want it where in the downtown area, in the CRA district. How do we allow that to happen in a kind of measured way so that the city gets the growth that you desire, but it's in the form and shape that you want? So from staff's professional experience, that would be a planned unit development. That's a cohesive development, typically mixed use. And within the CRA, that project would go before this board, then the CRA, and then the city council. And it's a discretionary permit. So if the city council doesn't like the proposal, they don't have to approve it. It's a different beast than a permitted use. So that is why, and then getting back to the height provision, Marina Grand is, I believe, 25 stories. Because currently the zoning code does not allow PUDs within the CRA at all, right now we're saying, listen, we're cracking that door open a little to achieve what the city wants and get some more economic development, but we don't want to throw the door wide open, right? And so staff's position in proposing this is to say, look, let's crack the door open, let's be conservative. There's other mechanisms where additional height or density could likely be achieved, but let's try to take a first step, because once you grant property rights, if you adopted a code that says we authorize 300 feet building or 30-story buildings within the CRA, once you grant those property rights, you can't reel them back in, right? You can't do that. That's not how it works. So we really need to be thoughtful about the form, density, and scale of development that the city wants. Another change is to Chapter 31, Section 31-534, downtown districts generally. The intent is to allow new IHC PUDs within the CRA and correcting 2 typographical errors. This section of the code currently has language that says no new PUDs within the CRA at all. And so that directly stands in opposition to what we're hearing from our leaders, that there's a desire to have additional development concentrated within the CRA district. In fact, that's everything we've been working towards within our codes. So we're suggesting that we strike the language prohibiting new PUDs in the CRA, but then we proceed cautiously and conservatively, allowing some development rights, and then, proceed from there with what our leadership's desire. Again, you can never really reel it back, so your best approach is to go in a measured manner and then adjust. So in addition to those changes, we also are looking at PUDs require recreational amenities, and so the IHC redevelopment area, we'd like to make some minor revisions to the required recreational amenity package. Right now, the IHC PUD says the recreational amenity, every project has to have 1 tennis court. We think that the recreational amenity package should be broader and identify, yes, you need to provide recreational amenities, but does it have to be a tennis court? Is it, a recreational amenity, including but not limited to, a pool or a fitness center, and, that type of thing, a spa. So that is another minor change that we would like to include in this proposal. So the ordinance would also provide for applicability, conflict, severability, and codification, and for an effective date. So again, just to restate, the revision of these sections of the Code of Ordinances is to provide a mechanism for higher density mixed use within the CRA, and staff believes it makes sense. Currently, no new PUDs are allowed in the CRA. This restriction was put in place at a time when slowing unchecked development was important. Now there is an interest in allowing thoughtful mixed-use development within the CRA to increase the density and generate an economic benefit. This type of PUD would do just that. An IHC PUD requires at least 3 revenue-generating commercial operations in addition to the residential use. This is a way to support a higher density of development, otherwise that we currently allow by the code. This also would not permit that high-density mixed-use development in every single, section of the CRA. This is a way to do a targeted, apply for your project and, defend to the planning board and the city council why it makes sense where it is. That's a different permitting strategy than to say, we're going to pick, the downtown core district and we're going to allow 20-story buildings everywhere in that district, right? There's two different, it's a targeted approach to permitting and allowing economic development versus a broad brush approach to it. We think a targeted approach provides the greatest level of control to the city. So, because this is a PUD, it is a discretionary permit, not a permitted use, the city council can reject a proposal that they feel is not right for the city. So staff recommends that the Planning and Zoning Board approve the amendments to Chapter 31, Sections 31-483, 31-497, 31-500, which is the recreational amenities that I referenced, as well as 31-534, as proposed in ZA 2108. I will also say that there's no current pending applications relative to this proposal. We are just trying to meet the needs of the city as expressed to staff.
Sure. At this point, I'm going to go ahead and ask a question, starting with Mr. Brown.
Ms. Savage, I see a couple more typographical errors here. In section 31, 534, C2, first sentence.
31, section 31 what?
534.
534?
C.
C2, okay.
Where it says primary streets are intended to develop over time. I guess you meant you need 2 words there instead of 1.
Hold on, let me pull that up. Primary and secondary streets?
Yeah, should.
Mm-hmm.
Yes. To develop over time.
Oh, you want a space in there?
Yes, ma'am.
You are,
No, that's.
could you proofread everything for me?
Actually, though, she's
two-
just mirroring.
It means
what
2
the
different
code
things, though. Yeah, it means 2 different things. It changes the meaning completely. Section number 3, Marina Way.
Yep.
I say Lake Lagoon. I don't know if that's you want that, but that's optional. And E1A, second line. You have 2 froms there.
I'm sorry, can you repeat that?
1E.
31, 534, E1A,
Okay.
second line. Ordinance from.
I get it, yes.
I still didn't get it.
From is
There's a
repeated
double
from.
You have 2
On the
froms
second
there.
sentence, the 2 froms there.
Oh, okay.
So Madam Chair, may I speak?
That's already in there as a correction. That's one of the typographical errors that I referenced in the presentation, but thank you very much.
And also, what about 3A1? To the nearest one, in the space in there somewhere, 100,
Mm-hmm.
a space of an acre. 1/100,
One
so
100.
it's all together, of an acre.
Mm-hmm.
I still didn't get that.
Okay, 3A1.
3E1, yeah.
3A, A1.
Okay.
He's saying there should be a space between 1/100th of an acre.
Oh, okay. Thank you. I'm sorry.
Madam Chair,
Yes.
I just want to point out that it's not staff per se, it was an error from
Yeah,
2013
yes,
that
I-
had rolled
I
over.
understand, I
So
understand.
thank you so much, Board Member Brown. I wish you were here in 2013.
Is that it, Mr. Brown?
Yes, that's it, thank you.
Mr. Gallagher?
No questions.
Ms. Burgess?
No questions at this time.
Okay. Just two questions. The 220 stories, how did that come about? It's that particular height?
The staff's reasoning for that is that previously the IHC PUD Marina Grand was allowed higher, greater height. Then the city chose to say,
Is that in the CRA?
it's in, the yeah.
Okay.
And then the city chose to say, you can't do them at all. Now we're granting new rights, and so, again, staff thought about, RM20, RMH20. The other zoning districts over there that allow residential or potentially mixed-use residential are 20 stories. And so we felt that by choosing a similar height than the other developments adjacent to that district, we felt that that was reasonable.
Good compromise.
We weren't overly restricting, but, if you think about it another way, if we approve it this way at 20, and there's still a desire, say, by our city leaders to provide a mechanism for someone to get to 25 stories, we can modify the MEHAP program, and if somebody wants to have additional density, they could contribute to our affordable housing fund to get that extra density. We do have other mechanisms to apply additional relief to the code.
Okay, that's fine. One last question. Going to the example of someone who owns property, 3 inside the CRA, 2 outside of the CRA. You bridge that together to make the project happen. What if the neighboring person says, hey, well, I want to be in the CRA. You let this piece of property in here, and it's just one, piece of property, but I'm bumping up against it. I want to join in that aspect too because of the benefits.
So we're not letting people into the CRA. A PUD requires a minimum of 2 acres. It's typically a mixed-use development. I keep saying the Marina Grand. That's just an example that we all see. So we're not changing the CRA boundary. What we're saying is if you're proposing a development and you have an assemblage of properties, if some of your properties are outside the CRA, the city council could allow that to be developed as part of your project. But I do want to call out the language that we put in because you're making a very good point. It is an added benefit. So I just want to read into the record, property located outside the Inlet Harbor Center redevelopment area that is adjacent to or contiguous to a proposed IHC PUD and in the same ownership may be included in the calculation of the minimum site area of the project and developed as part of the project if it is demonstrated that the inclusion of that property provides an increased economic benefit, enhances the overall project design, contributes to pedestrian connectivity, and enables the provision of civic open space. So it's not just a giveaway, it's saying, if you demonstrate to us that having this land area included as part of your development provides these additional benefits, And that's something that they would have to prove to you, and then the CRA, and then the city council. We will allow you to develop that as one holistic project. We're not adding it into the CRA. We're saying if you prove to us that there's a benefit to the city for allowing that to all be developed together.
Okay, thank you. Mr. Wiley?
No questions.
Ms. Shepherd?
None.
Mr. Fernandez?
Just one line item for clarification. You started mentioning the 20-story for the inlet harbor, but then you mentioned in the CRA, for instance, you won't allow a 20-story building on that property that on Blue Heron and 1, correct, where they're tearing down?
The code currently doesn't allow it there.
That's what okay, that's all the clarification I needed. Thank you.
Okay. All right, since we have no other further questions, may I have a motion to accept the staff recommendations as recommended?
So move.
Second.
May we have a vote, please?
Anthony Brown,
Yes.
James Gallen,
Yes.
Renee Burgess,
Yes.
William Wiley,
Yes.
Margaret Shepherd,
Yes.
Frank Fernandez,
Yes.
Evelyn Harris Clark.
Yes.
Unanimous vote.
Okay. Any workshop items, Ms. Shepherd? Sorry, Ms. Sabat?
No, ma'am.
Okay, all right, then let's go on to public comments. We have one from Mr. Frank Bozeman.
I believe you have two, yes.
I have only one card.
You have two, Madam Chair.
Welcome.
Madam Chair Fane Lozman, I want to explain in a little bit more detail what I'm talking about. The City Council adopted rules of decorum for public comment at public meetings. And the reason that they did that is the comments were running a lot of times till 10 or 11 o'clock at night, and people could not hang around to make their comments, elderly people that wanted to talk. So they adopted 7:30 time certain, unless you were in the middle of an item, and then as soon as that item went, you went to public comments. They also adopted rules of decorum, how those public comments have to take place as far as topics and stuff like that. And they post that rules of decorum at the front of the meeting. So I'm going to talk to whoever appointed you and ask if they're explained to you to please conduct these meetings not only to Robert's Rules of Order, but also to the rules that have been adopted by the City Council. So I don't want to come back here again and see an agenda that's not prepared in accordance with the rules that the City Council adopted for non-agenda public comment. I'm also not going to wait here past 7:30 unless there's an item pending. So what happened tonight was wrong, and I don't want it to happen again. Now, I have a couple comments I wanted to make. My property, I used to live on my property up until a year ago, or last fall. I had a homestead exemption on my property on Singer Island. They then downzoned the property to special preservation. So contrary to what Mr. Fernandez has said, the property did have value because it could be used for floating residential structures, number one. Number two, it's already been litigated. It doesn't matter when someone bought those properties on Singer Island. You may think it does, but it doesn't. We didn't spend millions of dollars and not do due diligence to understand what's going on. It's already been litigated that there is a vested right that goes back to 1924 to develop those properties. Okay, so this idea like, oh, well, you bought it and you should have known. The zoning was always residential till last fall, but it's already been litigated as to that. The savings clause is nonsense. There's a whole legal... we've had tremendous legal firepower look at that, and that's just a joke. And one of the things that should disgust you as a board is you should expect honesty in what is represented to you here today. There is a right in the state of Florida, really throughout the country, to protect one's property from trespass and vandalism. We got a permit for a fence on Pine Point Road. It was issued by the chief building official, a black woman, Lady March Goldwire. Councilperson Botel got Ms. Goldwire fired because she refused to rescind the fence permit. They fired her. Her replacement went ahead, allowed the fence to be built and inspected, and then Councilperson Botel said, we will remove you as our chief building official unless you put it back into review. We have not been allowed to build a fence on our property. They've allowed it to be torn down. So when they say wetland preservation, they say, well, you can't have a fence under the wetland preservation ordinance. That has nothing to do with it. It's a red herring they threw your way, and I think it's important that you recognize you've been duped here with some of the representations by Mr. Servants.
Thank you for your comment. Thank you. Mr. Sam Spector.
Thank you for hearing me again, board members. First of all, I would like to just say to you, I'm a property owner, commercial and residential business person. I have bought many properties. Some of them have panned out correctly, some have not. Some have cost me money, some have made me money. This is what America is all about. To say the Pledge of Allegiance to the United States of America and have freedom, we all have that. We have the freedom to purchase our properties, make our decisions, whether they work or not, that's individual. The fences in front of the property on Pine Point was not taken down. It had fallen down because of a storm. It has now created a sewer in a protected area. There's metal in the water, metal on the ground. It's incredible what's going on there. There was a lady walking down the street with some kids. They all ran to the water and played. One little kid fell and almost got hurt or did get hurt, and they came to me and said, who do I talk to about this? And I said, you have to contact the property owner. I don't own that property, but I maintain it. I make it look beautiful because it needs to be protected. So anybody can say that it was taken down. It was done by the storm, okay? And now you have poles sticking up. You have metal in the water. I have called the city to say, can somebody come clean it up? It's a protected environment and it's being polluted. There's a problem, disconnection. Whoever's at fault is not the issue. The issue is there is a problem, it needs to get cleaned up. Somebody needs to be responsible for it. I'm one guy. It's very heavy metal that's in that water. It's dangerous. Come look for it yourself. You'll see it. Okay, there's sharp items, metal sticking up. Nobody has done anything except for Mother Nature. And the property is beautiful. And it's been that way, as I told you. I've lived there since I'm 14 years old, and it hasn't changed. So erosion, there's no erosion. Not in my 35, 40 years of laying there, okay? I respect everybody's right to own property, to develop whatever they have to do, but not in a protected area. I firmly, and I feel everybody on Singer Island has spoken to stand up, and you have spoken to protect the environment of these areas. This is not about money. This is really about life. Living good, clean, healthy life, and I appreciate that. So if there's a way that somebody can come, look at what's in the water, you won't believe your eyes. It's like somebody just dumped all this stuff there. Who do I talk to? I don't know. Talk to this man? Absolutely not.
Thank you for your time, sir.
Okay?
Where is the property at, sir? On Pine Point? Okay.
It's in the middle of the block.
Okay, thank you.
You'll see that. A beautiful area. My mom is 95
This is inappropriate.
Madam Chair.
Go back to the mic so I can hear you, sir.
No,
I'm not.
No.
Now tell me,
Yes,
excuse me, tell me where it's at, sir.
It's in the middle of Pine Point, the middle of the road. And you'll see it's in a cleared area that my mother is 95 years old, and she has maintained and kept that
And
place so
I'm going to
clean,
have
picked
to,
up the garbage and everything.
Sir, I'm going to have to thank you for your comments,
Excuse
because
me, Madam
if I
Chair.
give you more time, I have to give the gentleman behind me
Excuse
more
me, Madam
time.
Chair, point of order, I asked him a question so I can go over and look at where he talked about. He has a right to say whatever he's saying for a board member to ask a question.
You
have no right to censor me.
We're not having this. Thank you so very much.
Point of order.
And we're going to go
Point
on
of
to the
order.
next item of
Mr.
agenda.
Sherman, point of order. I need an answer.
You've given an answer, and we can
He did
take
not
this
give an
offline.
answer. He needed to give a
Thank you so
clarity.
very much, please. Thank you.
You're an idiot.
Okay.
No.
All right, we're going to go on to correspondence.
Madam Chair.
Rules of decorum.
Okay, thank you so very much. And we're going to have Planning and Zoning Board comments. And we're going to start with Mr. Brown. None? Mr. Gallen?
None.
Ms. Burgess?
Madam Chair, we have a situation going on right here where it just talks about rules of decorum.
Folks, we're going to
Approaching
take
the
time out.
dais
We're in the middle of a meeting.
during a meeting.
All right, thank you so very much. Ms. Burgess?
Rules of decorum. Were we on correspondence? I do have, Madam Chair.
It's being taken care of. You know, it's decorum that we got to have amongst ourselves to follow our agenda. And we're doing really good, so I want to defer to Ms. Burgess to keep this meeting on track. Please, Ms. Burgess.
Thank you. I was looking over.
Oh, I'm sorry, Ms. Burgess, one moment. Please make note that Ms. Shepherd vacated her position here. And Ms. Burgess, please go ahead.
Okay, I was looking over rules of decorum as far as City of Riviera Beach council meetings, and I wanted to have our board attorney chime in because the last updates as far as rules of decorum I see was in 2011, and I just wanted to kind of go through real quick since some stuff just happened. One, no talking during meetings. Two, impertinent remarks prohibited, turning out cell phones, obscene or insulting language prohibited, and that includes members of our audience as well as our board members. Let's see, do not approach the dais. The official way you're supposed to handle if you have a public comment is to use a card. And then our sergeant at arms. But if our board attorney can go ahead and let me know if what I'm looking at is the most current, because I see nothing in here about a time certain and members of the public having to speak by 7:30.
Okay, Chair. So there was a subsequent resolution, and that's resolution number 9116. And that particular resolution I can circulate to the entirety of the board. That is what the resident, Mr. Lozman, was referencing. That resolution changed the start time of the regular city council meetings from 5:30 to 6 p.m. and provided a time certain for public comment at 7:30 p.m. This board, however, has made its own rules of decorum and has set its own agenda, and specifically this resolution, you do not have to follow. It is exclusive to the...
I'm very clear on that. That's why I went ahead and proceeded as I did to follow the agenda, and also in response to a board member also not being appropriate, changing the agenda. That was out of order as well. So that's why I stuck, and I continue to stick with what's outlined here. And if there are going to be any changes to the agenda, such as that we have public comments by the public on the item who submit cards right after staff speaks, we've already delineated that. So I thank you. I thank Ms. Burgess. I'm very clear. I knew I was not out of order, and we went ahead and proceeded.
Thank you, Madam Chair. I just wanted to have that that feedback read into the record for the public.
Thank you. I appreciate that, and I also appreciate each of our board members as we work together to keep us together as a team. So that was the last item. Let me go to Ms. Burgess. I didn't have anything right now. I'm going to Mr. Wiley.
Yes.
Planning and zoning comments.
Oh, well, my comment would be just what we just spoke of. Again, I apologize to the board for having the resident come up here, but I wanted to make sure that his needs were taken care of, and I wanted to be able to go over and be able to take a look at it to see what his complaint was and see if it's a legitimate complaint. So my apologies to have him come up here to get his information. It won't happen again.
And I understand we're learning in the process, and sometimes it takes one person to throw a wrench into everything. But apology accepted. Mr. Fernandez?
The only thing I'm stressing is decorum. We have an excellent team. We cannot demonstrate certain behavior in front of the public.
And I certainly agree with that, and just as much as we talked about what's being presented in front of the city council, let me say on record, when we have behavior by board members who contradict what we're trying to do here, we're going to have a discussion about that, because it's happened too many times, and right now, it's not going to ever happen again on my watch, not to me and not to anybody respectfully on this board. So, with that being said, we don't have any more business. I want to wish everybody a very happy holiday season. I want to wish everybody a happy new year. I'm wishing you and your family love, peace, and happiness, and most importantly, just be a prayerful for those people who are going without this holiday season. And just to close out everything, I want to say a tremendous thank you to each and every one of our board members, because we volunteer our time, and we volunteered in this instance to 9 minutes, 9:06, so we stay here a little bit longer to take care of business. I appreciate you on that. I appreciate staff, and I appreciate everybody that works here. You too, guys. I appreciate everybody that stays and help us take care of city business.
Absolutely.
With that, may I ask for a motion to adjourn?
So moved.
All right.
Oh, God. I've been. Oh, yeah, the, when you see.